Good afternoon, everyone. Once again, those of us who've been joining us on this journey, we are revisiting a very familiar topic for anyone who runs a business, which is dealing with the somewhat challenging issue of misconduct and performance. I think for those of you who are joining us today, this is a fairly familiar issue. As much as we would like to think that when we recruit people and we offer them work and they come and join us in our businesses, that they would be both competent and sensible and loyal, and that they would have a level of control over their behaviours such that they could just contribute to the business and to a positive culture within the workplace. But the reality is that that's not the human condition. And if there's anything we do know about human beings is that they are somewhat flawed. So what it means is that this is a really critical part of ensuring that businesses can get about achieving their outcomes, whether it's a not-for-profit in meeting the needs of a section of our society, or indeed a for-profit in getting a return for the investors. So I'm going to take a slightly different approach today. I'm going to try and keep this presentation fairly practical. I've deliberately avoided including cases and detailed analysis of cases. Rather, I'm trying to come at it from a perspective of my experience in advising clients day in, day out on this issue, and what are the best strategies for managing this process. It's ultimately, if we accept the fact that human beings are flawed in various ways, inevitably it means that the job of the manager or HR is to work out which of those employees' values do not align with the values of the business, or indeed they're just simply not competent to carry out the role. And in removing them, we open up the opportunity to get someone who can better align with the value of the business, or who is able to carry out the job in a competent manner. And that's a win for everyone, for management, for employees, and indeed for the clients. So the starting point would be, so let's look at a situation where we have an employee who has been with you for an extended period of time, perhaps 18 months, and you're noticing by then that you'd hoped in your heart of hearts that they might improve the performance that they were delivering for the business. When I'm talking to my clients, what I have in mind is what I describe as the 73%er. That is someone within the workplace who does their job most of the time, but rarely exceeds expectation, rarely shows initiative, rarely works hard, longer hours than they should. And often you'll find that such people may also be engaged in misconduct of some sort, which may indeed reflect the very natures that make them average employees. But they're not terrible. And so the question is, what do we do? So discipline or termination, to act or not to act, that's the question. And the starting point is to identify what conduct they are engaging in. Now, often these matters will come to you, either they're engaged in poor performance or they're engaged in misconduct. If they're engaged in poor performance, this may come to you either as a result of a client. You've sent them out on site and they simply didn't achieve the outcome that the client wanted. It may be that if it's in a professional services firm or indeed in sales, that their results are uninspiring, that they're not meeting the targets that they are meant to meet. And in either whether you are dealing with someone who's engaging in misconduct, in which case their behaviours become a threat to the viability of the business, the relationship with particular clients, or ensuring that you maintain the best employees, because good employees do not put up with working alongside people who behave in an aberrant fashion, or if the good employees have to carry the rest of the team in the performance stakes. So that's the first thing. Now, the conduct may be explained to you by way of complaint, by a manager, by a colleague, or by a client, or as I said, it may come to you via a monthly report in relation to sales or billings for a particular employee. Now, at that point, you need to engage in a decision. Do you need to go into a detailed fact-finding investigation? And I'll get to that towards the end of the presentation if you do. Or can you move forward on the information that you have, knowing that you're going to potentially give those employees an opportunity to speak and give their side of the story before you make a decision about what you're going to do? Just say you have received the information, then the next question is this behaviour curable? Now, I think there's some behaviours which are not really curable. Dishonesty is not curable. If someone shows themselves to be dishonest, it's very difficult to ever trust them again. And accordingly, I don't think there's any option but in that situation but to look towards terminating people. Likewise, if someone engages in behaviour which is certainly of a sexual nature within the workplace, if they lose their temper and they engage in some violent behaviour, that's another area that it's very hard to trust that they won't do so again, even if you feel that deep down that they are a person who doesn't necessarily, in their better moments, want to engage in such behaviour. What the business or the organisation can't deal with is the risk, a risk that they don't need to carry, of someone engaging in a behaviour which is going to go to the very heart of the viability of the business or the organisation. So that's the first question. Is it curable? What are the risks of not acting? We're going to move on to the alternative, but one of the questions that often employers do not ask themselves properly is what those risks are. Now, we're going to look at that in the course of this presentation, but it's a critical question. If you just ask yourself the question of what are the risks of acting, and you make a decision that you're going to move to deal with this employee's poor behaviour or their poor performance, and you're weighing up what that will mean as far as potential legal suits against you, and what are the legal costs and what are the potential outcomes as far as a compensation claim, all of that, that is a risk, but there are genuine risks to be found in not acting, and we'll explore that in the course of this presentation. The next is the question of formulating a strategy from that point. So once you do decide if you are going to take action from a disciplinary point of view, then you need to formulate what that's going to look like. It may be that you decide that you're not going to act in a formal disciplinary manner, but you're going to try a different approach. And that different approach may be that you simply give them additional resources by way of coaching or mentoring. Now, or you put them in a formal PIP program. In either situation, if you're not going to move down that formal disciplinary process, then you've got to be able to resource that, because that can be quite intensive, trying to properly mentor or carry out regular performance meetings in relation to a employee that's not doing their job. Then the final issue is you've got to resource that response, and that is going to be quite that can be quite tricky to do, because if people are in a busy in a business that it has only the staff it needs to get through the basic operational requirements, how are you going to find the time to have a manager sit down with an employee once every week for an hour? Can you do that? Is there someone available to do that? Or are you going to move that person to another part of the business? And how's that going to work out? Is there someone there that can induct them into that different area? And is there someone there who can properly supervise them? So that's another question to ask yourself. And if you're going to go down the path of potentially, for example, carrying out an investigation, how are you going to resource that? Who's going to do the investigation? It's going to be internal or external. If it's going to be done external, it's very difficult to get away with a proper investigation externally for under $20,000, and often it can extend upwards from that for more complex ones up towards 30 and 40 and even more as far as just the investigation costs. So there's a resource. Then you've got to have someone who's coordinating that on behalf of the employer. So there's that resourcing. So these are critical questions to ask yourself in that process. Then there's a question of who's at risk if you don't do something. So and I see this all the time, I see that an employer will have an employee working for them who's just not doing their job properly, or that they're engaged in behaviours which is impacting upon those around them, and they just ignore it. Or indeed they're largely incompetent employees, or certainly only sporadically competent, and they're sending them out on site to deal with clients or customers. In those situations, how are you going to manage that going forward? Because there could be a real cost associated with that. If you lose a key client because of the behaviours of an employee, because you're unwilling to deal with that behaviour, what is the real cost there? I think this is a critical issue to weigh up. And sometimes it can be that you've got an employee who is, and they might have, for example, an addiction issue, and you've got a contract with a large supplier or a large client where your staff are on site. In that situation, what is the risk of that person turning up to that workplace and failing a drug test? How does that go to jeopardizing your contract with that client? What does that mean to the business? What is the cost of that employee being left alone to continue to behave in the way they have up until this point? So you need to do that analysis across the full gamut, the full range of stakeholders in the business. Then there's the question of if you're going to terminate someone, how you're going to do that. And that is there's a range, and employers don't always go through a formal process in relation to terminating employees. Sometimes they look to other methods of terminating employees rather than the conventional termination on the basis of unsatisfactory performance or poor performance. It's very common, for example, for employers who see an employee who's either a risk to them, either by way of misconduct or by poor performance, just to allow them to continue in their role until, for example, there's going to be a round of redundancies coming out. And at that point, they terminate the employee, potentially along with others, by way of redundancy. If that employee is a longer-term employee, that can be an expensive option. So if someone's been there for 5 or 6 years, you're looking at paying an amount of another 10 weeks or plus by way of redundancy on top of their notice period and the various entitlements. So you've got to weigh up the cost of doing that. And even if you do terminate them by way of redundancy, if a court decides that actually that was a contrivance, then an employee can ask for their job back if they say it wasn't really a redundancy and they're being picked on for other reasons. So there was a case involving, for example, and we'll talk about this in the week that we deal with the restructuring. There's been a case involving Macquarie Uni where they ended up paying a lot of money to an employee who they decided they wanted to terminate by way of redundancy because they had real concerns about her performance. And that cost the university $600,000 in a final judgment. And also on top of that, the costs, which I suspect would be at least would have been at least that, and if not more. So that was an expensive exercise for the employer. So you got a choice of how you're going to go ahead and deal with this. Now, the conventional way is obviously terminating them on the basis of their poor behaviour or their poor performance. Now, and it can be obviously if it's poor behaviour, sometimes it extends towards being serious misconduct, which has different implications associated with it, but it still is a more aligned process of terminating them for other reasons, to do with redundancy. There are circumstances where you can just terminate an employee and you don't need to have a reason to do so. And that is in two particular areas, is the area of probation, and also if they're a high income employee who is not covered by an award. Now, there are a bunch of high income employees who are covered by awards. For example, engineers, a high income threshold now is 191,300, and engineers often earn a lot more than that, maybe 250,000 plus. In such circumstances, but such employees, even though they might be on $300,000, because there's a professional employees award, which includes engineers in those circumstances can be award covered. And if they are, they enjoy the benefit of unfair dismissal. But if they are not covered by, but if they earn more than 191,300 and they're not covered by an award, then you don't need to go through the process of issuing warnings, etc. You can simply walk into their office, tell them that it's not working out and that you're going to pay out their notice period, whether it's under the contract or statutory notice period. In either situation, they will they will not have the option of an unfair dismissal claim because they are high income employees without award coverage. The other situation is, of course, in probation. Now, that question of whether they can bring a claim for unfair dismissal doesn't extend to adverse action or general protections, which we'll talk about in the course of this. That is available at any time to both, and not just limited to employees, but also to contractors and sometimes others in relation to as an opportunity to seek compensation. So, but, unfair dismissal is still an area that people there's still an option for employees who feel like that they have been poorly treated on the way out the door by their employer. And so it's still relevant to understand the exceptions to it. Okay, so once you are terminating someone, then there's a whole raft of options that employee or former employee has to bring a claim. Now, in some jurisdictions, like in state jurisdictions, like the New South Wales one, which basically applies to government employees and council workers, in New South Wales, employees can bring a claim for unfair dismissal just when in the face of a threat of termination rather than actually after termination. But by and large, you've got rights in relation to unfair dismissal. You've got rights in relation to obviously adverse action. We'll talk about them. The employee can run off to work health and safety. They could run a potential discrimination claim, arguing that they were singled out on their age, or they were singled out on their race, or more commonly singled out based on a disability, which may be a long-term disability. Now, we'll talk about terminating employees who are unwell in a later lecture, but that's for anyone who's terminated. They may stick their hand up and say, the reason I was terminated, the reason I was behaving badly is because I, for example, had a brain tumor or some such thing in a more dramatic sense. But so you've got discrimination, and then, of course, employees for a long time now, after being terminated, a lot of them have run workers' compensation claims based upon the fact that they feel that the employer has not acted fairly and hasn't followed the procedure. So in such circumstances that they run workers' compensation claims. And up until the 1st of July this year, that was a pretty good idea if you're a worker, because it was very hard to lose. But what's become apparent, and since the 1st of July, is that under the new legislation, it's going to be more difficult for employees to make workers' compensation claims. For example, based on the fact that the employer failed to follow a proper process or grievance process, etc. So that's the risks there. That's the legislation. All that legislation really does intersect around this question of termination and whether the process that you followed was discriminatory, or whether it was reactive to someone asserting their workplace rights, or whether it was just unfair. So that's why the whole dynamic around termination can be quite fraught, because it is complex, because of all this different law intersecting at that point. Okay, so we're all pretty familiar with this stuff. No one really would be surprised by anything that we've got down here as far as written warnings. So it doesn't, depending on the nature of the misconduct, for example, if you've given a couple of warnings before terminating, and the conduct is not egregious, it's not like outrageous, or in the terms of the employment law, serious. If it's not of that nature, then there is generally an expectation that someone have the opportunity of being warned before they get terminated. There is a bit of an exception to that, which I'll go on to talk about. But if someone fits within the entitlements, the right to bring an unfair dismissal claim, then following through on a process where you're inviting them to a meeting, you're issuing them, you're setting out the allegations to them, giving the opportunity to respond, they've got a support person in those circumstances, and then you issue them with a warning in the aftermath of that, then you've got a good audit trail when their behaviour doesn't change and you want to take the more drastic step of terminating their employment. But all of that, I'm pretty sure, is pretty familiar with you folks. So where do people fall over? Where does it go wrong in the disciplinary process? Well, first of all, one of the questions is, if you're terminating someone, are they eligible employees? So have they been subject to the minimum employment period, what we call probation? So have they been employed for a business with more than 15 staff for 6 months? And small businesses, 12 months, but for most businesses, 6 months that they have to have been employed before they can bring an unfair dismissal claim. Now, this doesn't affect the other claim we're going to look at, which is general protections claim, but it does impact in relation to unfair dismissal. That's an important point. So do they qualify for it, for unfair dismissal? And if they are a high income employee, are they covered by an award? Because that also can impact upon it. The next option is, of course, general protections claims. They've been with us for a while now, and I'll talk about them a bit more in depth as to what they look like, but they are available, and it's important to note that they are available to be made at any point in the employment relationship, and they also can be made against third parties like contractors or principals. If your company's engaged, for example, to provide services to a mining company or to some other entity, and your employees are on site, then those employees, if they're treated adversely by that particular person or representative of the entity, then they can bring a claim against certainly the entity and sometimes the employee themselves. So now, general protections. So the next question is, if someone is a non-award employee, so as I said, they earn more than 191,300, or they, and they are not covered by an award. If they're non-award in that situation, then their rights are limited in relation to bringing an unfair dismissal claim, but it doesn't stop them bringing a general protections claim, which is, in my experience, where people tend to go. If you're a not-award employee, you don't have to go through the process of issue warnings. You simply can walk into someone's office and say to them, listen, we're really concerned with some mistakes you've made, and your general attitude around the office, we don't think it's constructive, we're going to let you go. And as long as you pay out their entitlements, including the notice period, then in those circumstances, you can terminate them and they don't have a right to bring a claim. So it's simply, it's a termination at will, as it were, without reasons needing to be given. So that's there's the portion of the employees who would be above the high income threshold of 191,300 and not covered by awards is quite slim, but they exist. So that's an important question to ask. There is another one, which is, if you're terminating someone, are you going to go about doing it in a way that's compliant with the award, or indeed more particularly in relation to the Act, the Fair Work Act? Because if you terminate someone and you don't comply, then they can bring a claim for breach of that particular award or enterprise agreement, and they can seek damages not just from you, but from others who are involved in it, and also they can seek a civil penalty, which can be a significant amount of money, up to $90,000, if they are it's found that you're in breach of the award. So how would you be in breach of the award? Well, a really simple way is, there was a decision handed down about a year ago, which says that you've got to pay people their what's called national employment standard entitlements. That's your notice period and redundancy and annual leave. You've got to pay them on the day of termination. Now, that's really confusing, because the awards say, or most of the awards say, that you've got up to 7 days to pay the entitlements. It's the way the court made that decision is they didn't rely on the award, they relied on the entitlements under the National Employment Standards in the Fair Work Commission, and Fair Work Act, and they really didn't give a good explanation as to how they got to that issue of 1 day. But I actually encourage my clients to be, if they want to be uber compliant, then they really should be making their termination payments on the day the person is terminated. And then the final one is discrimination. We kind of think we all know about discrimination. So this discrimination can be in the forms of discrimination based on race or disability or sex discrimination, etc. Now, that is, and there's direct and indirect discrimination. For example, or direct or indiscriminate. Yeah, so for example, if you were to issue a warning to someone and at that time you were becoming a bit hardcore with all employees within the workplace, not just this person, and he could potentially run an argument, or she could potentially run an argument, if indeed it was true, or at least had the look of apparent truthfulness, that the that the rule that you set for the termination, that is, your position was whenever anyone does X, we will terminate them, and that's a rule within the business, then that would be indirect discrimination, because if that person had, for example, a disability which made it difficult for them to comply with whatever role or function they were supposed to carry out, and they didn't carry it out, but other people who didn't have their particular condition could have carried it out, then you've got a discriminatory situation, and that is sometimes the case, particularly when you've got someone who is showing aberrant behaviour based on their some sort of claimed psychological condition. In such circumstances, they might try and discrimination on you by saying that, hey, you didn't properly support me, or you didn't to enable me to behave in an appropriate fashion. So anyway, there's a quick look at the variety of remedies that are available. So as I said, when you're making the assessment as to whether you're going to terminate, then some key things you might want to run past is this question of entitlements upon termination. Because if you're going to terminate and you've got to pay soon, you've got to make sure you get the money in the bank to do so. But you also note that you've got to do it correctly. I'm currently acting for a client at the moment that terminated an employee and paid them some superannuation contribution, and it turns out that superannuation contribution was incorrect. Now, it was rectified pretty quickly, but the employee, notwithstanding that, has brought a claim in the federal court against our client, seeking civil penalties, even though they didn't actually lose any money. It's just the fact that it was a breach of the award, and they were slow to pay it. So, as I said, 15 employees at the beginning will give you the option of the small business dismissal code. Your probation periods for small business are longer. That is up to 12 months if they've got less than 15 staff. And the high income employees, you're entitled to terminate a high income employee who's not covered by an award, or industrial enterprise agreement, then you're entitled to terminate them, as the Americans say, at will. That is, without a reason be given. You can simply come in and say, listen, I don't like the cut of your jib. I don't think it's working out here. Pack your things and can you shoot off? So that is, and that's only available to employees earning more than, with a guaranteed income of more than 190,100, and who are not covered by an award. So that's just a little bit of a checklist. So what we're doing is we're moving on to the obvious question of unfair dismissal. Are they eligible, i.e. have they done are they in probation? Are they a high income employee? Do you have a valid reason for the termination? Now that is, often employers are able to establish a valid reason, which is maybe the person has been found to have stolen money from petty cash, or that they were engaged in an unnecessary and particularly abusive argument with a client or a colleague. that can certainly present a valid reason for terminating them without further warnings. And then the next question for unfair dismissal is, was the process reasonable management action? That is, was it fair? And then finally, weigh up the risk of, is it possible that the employee would actually take this all the way through to the Fair Work Commission and to a hearing? And in such circumstances, if our evidence was not believed, is it possible that they would be reinstated to the rule or directed the employer to reinstate them and make them back pay? How do you deal with that as far as financial loss or loss of resources in fighting this claim? That is, or indeed the question of reinstatement. How do you reinstate? Is there a risk that that individual will be reinstated into your business, which could be a real nightmare if you've sacked them? So that's your unfair dismissal. Unfair dismissal is a lot about it. You're all familiar with it because it's been around for a long period of time. It's very much about if they're eligible for it, then it's about not only that there was a good reason to terminate, but also you went about it in a way that was fair. Okay, so general protections is a different issue. General protections is not so much about the fairness of the process. There's an element about the process in there, but it's not to do with the fairness of the process. It's about whether or not someone has exercised or not exercised a workplace right, or that they're being terminated kind of replicates the Discrimination Act that for a discriminatory reason. Now, in both those situations, there's the opportunity for the worker to recover, not just against the employer, but they can bring such a claim against other members of management, for example, or even clients. And that's what makes it so concerning, because a smart employee may threaten to bring a claim against a key client, or at least drag them in there, even though they haven't done anything, but simply because they know that it will be an effective tool of leverage. So just important to realise that adverse action is not about whether it's fair, it's just about the nature of the reason. So what is adverse action? It could be termination, it could be demoting, it could be a change in someone's job to their detriment. So it can include such things as maybe changing a roster to remove them from doing weekend work, which is more remunerative. That's a form of adverse action. It could be that you cut back on shifts allocating shifts to them if they're casual. Or it could be that you move them to just a different office. All of that can be adverse action, and simply issuing them with a letter of warning it can be adverse action if it was found to have been done for an unlawful reason. So, but it's not to do whether or not someone's been given the opportunity to respond to each allegation, etc. It doesn't deal with any of that fairness side of things. Now, one of the important things to understand about adverse action is the obligation is upon the employer to prove that it was not their employment or the complaint they made to their employer or some other third party in relation to their condition, or indeed that the person was aware, that they knew, the boss was aware that they'd had 6 to 8 weeks off in Europe. In such a situation, the onus is upon the employer to prove that that was not even one of the reasons. We're in the middle of this in such an action, and it's really quite tricky to do at times, to prove that you were motivated purely by noble and lawful reasons in terminating the employee. One other issue to think about is the question of notice, where someone you're going to terminate their employment, then unless they've engaged in serious misconduct, which could be some sort of sexual assault, it could be just violence in the workplace, it could be theft, all of those can amount to, and would generally amount to, serious misconduct. In such circumstances, you don't have to pay the notice or give or pay the notice. You can simply walk them out the door. Now, the other area where you don't need to pay notice is they haven't formally reactivated or that they don't have a contract in place, and so there's a test, or they haven't, when they've done a variation of the contract, they haven't done it properly. So there's no clause within the contract in relation to the notice period. In such circumstances, the notice period will be reasonable notice. And if it's reasonable notice for someone who's a senior employee, that can be 3 or 6 months. At the moment, I'm dealing with an employee and a senior employee, and we're suggesting that the reasonable notice for that is could be up to 6 months. That's an employee who's a CEO, who's on about $250,000, $300,000 a year, and has been there in the business for about 9 years. In such circumstances, we're saying that that's what the notice period is, that it's somewhere between 3 to 6 months. And in my view, we're on a winner there. Now, what I want to do here is do a little bit of a triage about what are the issues that we consider when we're going to terminate someone, because there's a range of different legislation that they may reach for. Workers' compensation, up until the 1st of July or 30th of June this year, workers' compensation was a really good option for employees who were terminated. It was quite easy to run a psychological injury claim. It was quite difficult for the employer to resist it, because there were a couple of reasons to do with that. The test was a subjective one, and basically if the employee felt upset by their process, then essentially that was it. And there were only a narrow range of circumstances where the employer could run a claim of run a defence of reasonable management action. So, our firm does a huge amount of workers' compensation for iCare, and talking to the people who worked in that team up until the 30th of June, dealing with site claims, they would say, listen, it's really hard to resist that. The reasonable management action defence is quite limited. All of that has changed as of the 1st of July. I'm not going to deal with that in this lecture or this presentation, because I'll deal with that on the, I think it's on the next occasion. I'm talking about dealing with ill and injured workers. But I will simply say that the prospects for an employer to resist a spurious claim now, for a psychological claim, are much higher. And so that in some respects means that the workers' compensation as an option may be diminished now, which empowers employers to look more closely at the option of doing a fairly conventional termination for misconduct or poor performance than before the 1st of July. All of that is in New South Wales, of course. Now, just say the way a claim under the new system would happen is if there was repeated incidents, if there was bullying, which can be repeated unreasonable actions on behalf of the employer. Now, if you don't follow process, that can arise. And sometimes for a variety of reasons, process can be difficult to follow for practical reasons. Now, if there is a risk that a workers' compensation claim could arise and that it would be accepted, then a very relevant question is, what impact, if that person sits off from workers' comp for an extended period of time, what that's going to do is to your premiums. And the bigger the business, the more likely it will significantly impact upon the business. There's a second question, of course, in workers' comp is, are you able to follow a process which is fair? Now, we've been talking about that, mapping that out before with the letters, where you invite people to a meeting via a letter. They can have a support person. They turn up. You've got a support person. They've had the allegations from the letter, and you go through the process of discussing that. You listen to what they say. You're unconvinced by it, and you think that the allegations are likely to have been correct. In such circumstances, then in such circumstances, you can move forward. Now, as far as discrimination is concerned, it will arise generally. You have to be a bit careful if, for example, you've got a workplace that is fairly monoculturally. Probably, you know, I've lived for a while on the Central Coast north of Sydney, and for a long time it was a real monoculture, pretty much very little in racial diversity. So if you had someone in the workplace there and they were the only person you terminated, then you obviously leave yourself open to a discrimination claim. Or if someone in disability is probably the most likely one, and people have a whole range of disabilities that didn't really exist before, and it's not uncommon for people to run claims in relation to discrimination on the basis of such things as being on the autism spectrum or having ADHD in such circumstances, particularly if it's been properly diagnosed, it can raise issues around termination as far as opening up the door for a discrimination claim. Okay, but it's critical. The bottom line is whether it's adverse action, unfair dismissal, or discrimination, if you can point to having a valid reason, and that valid reason was the motivating reason, and the unlawful reasons were not, in a way, motivating reasons which actuated or at least significantly contributed to the reason for terminating, in those circumstances, you can avoid that. That can be tricky to prove at times. So your paperwork on the lead up of that, making it very clear as to why you're going about it, and that it's purely to do with performance or purely to do with conduct matters. In such circumstances, then you can proceed. But it's very important that is documented, the reason why you terminated them. We talked a little bit about unfair dismissal and the probation and high income, how they can preclude them from being an unfair dismissal claim. One of the factors of worrying about what sort of remedy is if someone is on a high income, then if they're not on a high income, it's often the damages that get awarded are not prodigious. They're fairly modest. You know, sometimes the court may decide that a person has been unfairly dismissed, but they're only entitled to 6 weeks' pay, and or sometimes even less. So that means that you've got to weigh up in that situation whether you can settle it at a conciliation for a lesser amount, but you might be able to stick to your guns because in the knowledge that the employee is unlikely to get a large settlement out of this, or sorry, not a large settlement, a large judgment out of this. High income employees tend to be able to argue that it's going to take longer for them to find work and therefore longer for them to, that they will be without income for an extended period of time, so their claim for compensation is higher. Just one other issue to do with general protections claims. Unlike unfair dismissal claim, where you can only sue for the loss of income, with general protections claims, you can you can sue for non-economic loss. That is what we would describe as pain and suffering. That is distress that arose out of the behaviour or conduct of your employer or another employee there. One of the areas that employers, particularly for unfair dismissal claim, they come undone is in policies. It's just critical that you actually have a policy in place, not just in relation to the termination of staff, but you have a properly drafted policy that is practical and that you can follow it. I cannot tell you the number of cases that come a cropper because of the absence of a policy or having bad policy. And not just those policies, the policies you're going to rely upon, that firstly they're properly drafted, and that there's evidence that the employee has seen that policy, and that they've been properly inducted into them. Now that's the case, particularly around drug and alcohol. Most of the cases turn on it's either an employer having a poor having a poor policy in place or simply not following the policy. Now, there was a case up in the Christmas Island involving a guy who ran a really nasty campaign against his work colleague, where he belittled him in front of all the other staff. And the things he said to them were of a sexualized nature and just demeaning. Anyway, the individual who did that was processed by the employer. They were invited to a meeting. They had a support person. The allegations were read out. They were terminated. When I read it, I thought, when I read the facts, I thought, yeah, they absolutely should have been terminated. This person is a nightmare, and that really would have mucked up the mental health of the person that he was regularly belittling in front of his colleagues. Now, in that situation, where the employee got terminated, had success is that there was a policy in place in relation to conduct within the workplace and how one spoke to one another, and basically anti-bullying, and they could not prove that this individual had been given a copy of the policy, and certainly couldn't prove that the individual had been inducted into the policy. Again, that induction side of things becomes really important around policies for drug and alcohol. It's very common that employees will say, I didn't know about the policy. Or in relation to drug and alcohol, they might even go further and say, yeah, okay, I knew about that, but I had drinks the night before and I didn't know that alcohol lingered in the blood, or I went to Bali and I had some marijuana over there and then I flew back and 3 days later it showed up in my system. No one ever explained to me, they never got a pharmacologist to explain to me how long it takes for such drugs to dissipate from within the system. So it's really critically important. Make sure you have policies that set out expected behaviours, and that those policies are properly, that you've got a record of this, all employees reading them, and that they've, where there's some sort of induction required to make it comprehensible, that is carried out, and that the attendance of the employee at that training you've got evidence of it in your records. Probably one final thing I will say is employment dispute insurance is really critical in determining what sort of level of risk you're going to take on the termination. There are a number of policies around. They're available by all the insurers. They're an addendum to your your general insurance. You can add a module on, but the experience my clients have had with them are very good. I'm actually not on the panel of any of them. I'm on the panel of iCare for this new legislation, which is going to flood us. So I've been a bit shy about being on such panels for a variety of reasons, which I won't bore you with. But when you've got that insurance, then the employer will step in. Sorry, the insurer will step in, and they will appoint a lawyer on your behalf who will act for you. So you save legal costs. You may have to pay out the amount at the end. It depends on whether it's an underpayment or whether it's some sort of just general compensation. If it's general compensation, then generally those modules to additions to the policy will cover that. I cannot encourage you, and it's really quite cheap, certainly compared to workers' comp. I'll say one further thing on workers' comp. If you think you are at risk for a claim arising out of the way in which termination occurred, then, and you are a business that's of a reasonable size, you've got 200 or 300 employees, you've got to be really across what the likely cost would be to the business if that individual puts in a claim for workers' compensation based on the way that they were terminated, and they are successful and they remain off work for 6 to 12 months. That could drive your premiums up by hundreds of thousands of dollars, which is a far greater concern than an unfair dismissal claim. It's really important that you understand the two questions when you're terminating someone. As far as are we a business that's large enough to get a significant claims loading? And is the process we're going to go about, is it going to be orthodox and compliant? If it is, then that's great. So I'm just going to run quickly through some investigations, and it is going to be quickly because we've only got a couple of minutes. Even though we've got a lot of slides, they're only one word per slide, so they're like flashcards, and I will send you the slides and you'll see. But here's some about 10 or 11 comments on the way you're conducting an investigation. Firstly, identify whether you need one. If it's not a serious matter, and if you're likely just to issue a warning, then And if someone's health and safety is not at risk, then, or indeed there's not a suggestion of dishonesty, then you may not want to engage in an investigation. The other reason you may not want to engage in investigation is you may not need to establish, go through the process of warnings for the staff member because either they're in probation or indeed that they're high-income employees. Again, if you go through an investigation and such people get the sense that their jobs are at risk, they might go and complain about something and set up a general protections claim. So that's an important question, whether you need to carry out investigation in the first place, because the other issue about investigations is they are resource intensive, whether you're going to do it internally or you're going to pay it. The second thing is determine the goals of the investigation. Do you want to get the person to make findings of fact? What are those findings of fact that they need to, or are you then going to give that to your lawyers, those findings of fact, for them to give advice on whether or not you breached the law? And the questions arise at that point as to whether or not you want that to be subject to legal professional privilege so it can remain secret. Now, that's an important question, and that will go to this question of what are the goals of the investigation. So one of there's advantages, disadvantages. One is the cost of investigation, that's a disadvantage. And the other, of course, is the question of, is it going to, doing an investigation, you've got different people within a team, often giving evidence that may be against their team leader or another colleague of the team, and it may rip the team apart. Is it going to be better to do a mediation? And that will depend on the nature of the misconduct that's gone on. Select appropriate investigator. In our view, and we have really slung back to using junior barristers because they know how to take a statement, that they're actually surprisingly cheap compared to a lot of investigators, and they do a really good job, and they know how the process of making a finding where they've got to prefer the evidence of one over the other. So you then inform the employee of the specific allegations that are being made. You identify potential witnesses. You identify the documents to be reviewed. You got a question whether you're going to suspend the respondent or move them to another department or somehow or other separate them. Is that necessary? So there's that question. And if you're going to suspend them, you've got to pay them during that period. You can't not pay them just because they're under suspicion. Prepare a strategy for the investigation. How are you going to go about it? Is it going to be online? Are you going to, the investigator going to meet with the people in person? How's that's going to work? How are you going to maintain secrecy and confidentiality throughout it, where documents are going to be stored, where the investigation's going to be, where the meetings are going to be carried out, et cetera, et cetera. A lot of investigators these days do not want to meet face to face. They want to do it all online. So bear that in mind. So as I said, you've got to establish rules to secure the records, et cetera, so that you don't breach confidentiality. And you've got to get the right venue. And also, people coming and going to that can be quite awkward. So you've got to organise that. You're going to do it before work or after work, or you're going to do it in a different part of the building. How are you going to manage that? Because people often find it difficult being seen to go in to be given a statement. Then the witnesses will be interviewed, and they've got to be properly recorded, or they're interviewed. The questions have got to be properly formulated. Now, you really need to have a handle on that. And the questions that are going to be answered, are going to be asked, rather, are going to be determined by what's the outcome you're going to need from that, from the investigation. Then sometimes you're going to need to touch base with the investigator to see how it's progressing, whether it's on schedule, whether they need further documentation produced. A really common situation is that the complainant, the person against whom the complaint has been made, they'll raise their own complaints. And so you need to be aware of that, so that you might need to set up a separate process where you investigate that. That's really common for the person being investigated to raise their own complaints. Making findings. A lot of investigators resist making findings. You can't just say what was recorded. Sometimes you've got to actually make a decision and prefer the evidence. They've got to be willing to make a decision where they prefer the evidence of either the complainant and the respondent, one over the other, and sometimes between witnesses. But you often need an investigator who's willing to make findings. Otherwise, it's a pointless exercise. And then following through on the back of that is taking appropriate action. So there you go. Wow, 1 o'clock. I brought that in on time. So, Yoni, there's a record for you. If you've got any questions arising out of that, please send them through to me or Yoni, and we will address those. I undertake to get back to you with any of those questions. So thanks very much.